A High Court sitting in Kiambu has suspended the implementation of the National Dialogue Committee report pending hearing and determination of a case filed by activist Michael Muchemi. The petitioner told the courts that any attempts to have Parliament process the contents of the NADCO report will plunge the country into unprecedented constitutional crisis. Stephen Letor reports.
The implementation of the NADCO report that is before Parliament has been punctured by a court sitting in Kiambu, with Lady Justice Dora Chepkwony issuing orders suspending the implementation of the report. The High Court issued a conservatory order restraining the second and third respondents, that is the National Assembly and the Senate, from constituting any special sitting for purposes of debating, endorsing, adopting and or appointing a panel to implement Chapter 2, Paragraph 203-263 of the report of the National Dialogue Committee dated 25th November 2023 that seeks an audit of the 2022 presidential election pending hearing and determination of the application. In the petition by Michael Muchemi, Lady Justice Dora Chepkwony further issued a conservatory order restraining the second and third respondents, the National Assembly and Senate, from implementing Chapter 2 of the report of the National Dialogue Committee dated 25th November 2023 that seeks an audit of the 2022 presidential election pending hearing and determination of the application. Other orders granted include a conservatory order restraining the clerks of the second and third respondents, that is clerk of the National Assembly and the Senate, from implementing Chapter 2, Paragraph 203-263 of the report of the National Dialogue Committee dated 25th November 2023 that seeks an audit of the 2022 presidential election pending hearing and determination of the application. In his submissions, the petitioner argued that the presentation and submission of the report as is from the National Dialogue Committee to the National Assembly poses a direct challenge to the rule of law in Kenya as it seeks to conduct an election audit outside the constitutional framework. He told the court that the Supreme Court of Kenya has exclusive jurisdiction to hear and determine disputes relating to the elections to the office of the president, and his decision is final. Any audit at this point cannot change or reverse the decision of the Supreme Court through a constitutional and legal process. According to the petition, quote, if this application is not treated as extremely urgent and certified as such, the underlying constitutional concerns raised in the pleadings below may remain unaddressed. Further, the petitioner notes that it is therefore in the interest of justice that temporary conservatory orders be issued restraining the National Assembly and the Senate from implementing Chapter 2, Paragraph 203-263 of the report of the National Dialogue Committee, failure to which will result in further breach of the Constitution of Kenya. Parties have since been directed to file their respective written submissions within 7 days of exchange of responses, that the application be heard inter partes on 16th April 2024. President William Ruto and Azimio leader Raila Odinga had earlier this month called for a speedy implementation of the NADCO report without further delay. Stephen Letor, Citizen TV.